Hello, I'm Dixie Hieb, a partner in the Financial Institutions Practice Group with Davenport Evans Law Firm in Sioux Falls, South Dakota. Much of my practice focuses on the formation and ongoing operations of public and private trust companies. Today I'm going to focus on some of the key considerations in forming a South Dakota Trust Company. The formation of a private South Dakota Trust Company is attractive to families who are seeking more control over the investments in their trust accounts, as well as a possible reduction in their trustee fees. However, the most significant growth in the trust company area in South Dakota has been in the area of public trust companies, where the formation of a trust company may relieve an advisor of some of the otherwise applicable SEC registration requirements. Once a decision to form a trust company has been made, the next key decision is the jurisdiction in which the trust company should be located. South Dakota has consistently ranked at the top of the various listings regarding both trust laws and trust company laws. We have a business-friendly, low-tax state with legal advisors who are well-versed in trust and trust company law. We also have a positive regulatory environment with a division of banking that has overseen the growth of trust industry in our state. Application and operational requirements for a South Dakota Trust Company are fairly straightforward. However, if you're interested in forming a public trust company, there are some key takeaways of which you should be aware. The trust company will be required to have a physical office in South Dakota, staffed at least part-time by an employee or through an independent contractor arrangement. You will also have to meet the South Dakota minimum capital requirements. Although the statutory minimum is $200,000, the Division of Banking generally requires a minimum of $400,000 for public trust companies, with a higher amount for those companies seen as having greater risk, such as companies dealing in cryptocurrency. Of that amount, a portion must be pledged to the South Dakota Division of Banking. Generally, that pledge is at least $200,000. So a trust company must capitalize at an amount that ensures that its capital will not fall below the minimum required by the Division of Banking. A public trust company's board must be comprised of between 5 and 12 members, one of whom must be a resident of South Dakota, and at least one-half of whom must be citizens of the United States. The trust company's governing board must meet at least once each calendar quarter, and at least 2 of those meetings must be held with a quorum physically present in South Dakota. There are a number of other requirements and considerations to be taken into account in structuring a South Dakota Trust Company. The attorneys at our firm have assisted with the formation of over 80% of South Dakota's trust companies, and we work with a large number of trust companies on an ongoing basis. We can provide assistance at any stage in the application process. Please feel free to contact me or any one of our other trust company attorneys for assistance at 605-336-2880 or visit DEHS.com to reach a Davenport Evans attorney.